Good day, everyone. Let me ask you a quick question. Have you ever dreamed of finally owning something and saying, "This is 100% mine"? That's the power of an absolute deed of sale. A legal document that doesn't just transfer ownership, it seals it completely and irrevocably. Today we're diving into what makes this document not just important but essential. Whether you are buying your first car, selling a piece of land, or transferring a valuable asset, is often overlooked in its simplicity, but it holds the weight of security, transparency, and trust between buyer and seller. So in this presentation, let's break down what the absolute deed of sale is. Let's get started. A deed of sale is a legal document that serves as a proof of sale and transfer of ownership of property from a seller to a buyer. It's commonly used for the sale of vehicles, land, houses, or other valuable assets. The parts and structure of a deed of sale. The first one is the title. This tells us exactly what kind of legal document we're looking at. Most of the time, it's called a deed of sale or deed of absolute sale. This title sets the expectation that ownership of something valuable like land, a house, or a car is being legally transferred. The second one is the date and place of execution. This states when and where the deed was written and signed. It's important for legal timelines and to confirm when the ownership officially changed hands. Then we have the parties involved, the seller and the buyer. Their full names, age, citizenship, civil status, and addresses are written here. This section confirms their identities and shows who is giving up ownership and who is receiving it. The recitals or preamble give background to the transaction. This usually states the seller is the lawful owner of the property and that they are willingly selling it. It's like a short introduction to the story behind the sale. The description of the property is one of the most important parts. It gives all the specific details of the item being sold, like the lot number and size of its land, or the make, model, plate number, and engine number if it's a vehicle. This ensures that both parties agree on exactly what is being sold. The purchase price and payment terms tell us how much the buyer is paying for the property. It may also mention how the payment was made, whether in full, partial, or through installments. This section is essential for financial clarity and avoiding future disputes. The transfer of ownership confirms that the seller is officially transferring all rights and interests in the property to the buyer. It often includes a statement that the buyer now has full possession and control over the property. In the warranties or representations section, the seller promises that they have the legal right to sell the property. It also confirms that there are no unpaid taxes, debts, or legal problems attached to the property. Then we have the signatures of both parties. This proves that they both agree to the terms of the sale and are entering the contract voluntarily, or sometimes witnesses also sign here to add credibility. Lastly, we have the acknowledgement or notarization. This part is signed by a notary public who verifies the identities of both parties and confirms that they signed the deed willingly. Notarization makes the document legally valid and ready for registration, especially if it's for land or vehicles.
Here are the uses of absolute deed of sale. First is real estate transaction, second is vehicle sales, third is full and final sales, and fourth is registration and documentation. Here are the parties and as well as their definition and obligations. One of the parties is the seller, the current legal owner of the property. It transfers ownership and possession to the buyer. The other party is the buyer, the person purchasing the property, the new legal owner once the sale is completed and registered. The obligation of the seller is to transfer ownership, deliver property, sign deed, pay capital gains tax, assist in transfer. While the obligations of the buyer are to pay full purchase price, register the property, pay taxes and fees related to the transfer. Here are the functions of absolute deed of sale. First is proof of ownership transfer. It confirms that the seller has transferred full ownership of the property to the buyer. Second is legal evidence of the sale. It serves as written proof that a sale has taken place between the two parties under agreed terms and conditions. Next is acknowledges receipt of payment, which states that the seller has received full payment from the buyer for the property. Next is protects both parties, protects the buyer from future claims by establishing a legal record of the sale, and protects the seller by documenting that the property is no longer theirs. And last is the requirement for registrations. It is often a prerequisite for the buyer to register the property in their name with the relevant government agency. Absolute deed of sale is executed on the day the seller signs the document in front of a notary after receiving the full purchase price. Differences and effects of an absolute deed of sale versus conditional deed of sale are the following. In the differences in the ownership, absolute deed of sale ownership is fully transferred at the time of signing, while the conditional deed of sale ownership is not transferred until the conditions are met. In the payment, absolute deed of sale, the buyer usually pays the full price upfront, and it comes to conditional deed of sale, often used when the buyer hasn't fully paid yet. And for the condition, absolute deed of sale, no further conditions need to be met for the sale to be valid. And for the conditional deed of sale, it can include conditions like installment payments, obtaining a loan, or compliance with legal requirements. When it comes to effects, first, the ownership. When it comes to absolute deed of sale, the buyer becomes the legal owner right away. And for the conditional deed of sale, the seller retains ownership until all conditions are satisfied. For the rights to the property, for the absolute deed of sale, the seller no longer has any claim or right to the property, while for the conditional deed of sale, the buyer typically has possession or partial rights but not full ownership. And for the registration of property, for the absolute deed of sale, the buyer can now register the property in their name, while in the conditional deed of sale, they can delay the transfer and registration of the ownership with government agencies.
In deed of absolute sale, in identification of the parties section is crucial because it clearly states who are involved in the sale. It includes full legal names of the parties, the civil status, nationality, address, and the legal capacities of the both parties. In description of the property section of deed of absolute sale, the goal is to accurately and clearly identify the property being sold. This includes type of property, the technical description, the title information, which includes the title number and the registry of deeds location where it is registered, lot and block numbers, boundaries, and if it needs any improvements. In purchase price section, you need to clearly state the agreed amount the buyer is paying for the property and any relevant payment terms. This section usually includes the total purchase price, mode of payment, if it is in full, lump sum, or in installment, or via bank loan or financing, the receipt acknowledgement, and if it includes taxes and fees. The delivery and transfer of ownership section in deed of absolute sale is essential to formally establish that the seller has turned over the possession of the property and is obligated to transfer legal ownership to the buyer. In warranties and representation section of deed of absolute sale is crucial because it protects both parties, especially the buyer, by ensuring the seller guarantees the legal condition of the property and confirms their right to sell. It typically includes the legal ownership, where the seller guarantees that they are the true and lawful owner of the property, the right to sell, which the seller confirms that they have the full right and authority to sell the property, the peaceful possession, free from liens and encumbrances, and making sure that no hidden defects or legal issues. In taxes and expenses section of a deed of absolute sale, the parties agree on who will shoulder the costs related to the execution and registration of the sale. It usually covers the common taxes and fees involved. Some common taxes and fees involved under this contract is shouldered by the seller are typically the capital gains tax, unpaid real property taxes, commission to real estate broker. And taxes or fees shouldered by the buyer, this usually includes documentary stamp tax, transfer tax, registration fees, and notarial fees. In notarization section, it is the final and formal part of a deed of absolute sale. It is called the acknowledgement clause, and it is where the notary public certifies that the parties personally appeared, proved their identities, and voluntarily signed the document. It usually includes acknowledgement statement, where the parties confirms that they are personally appeared before the notary on a specific date and place. It also verifies their identity through a government-issued ID. It also includes the notary's details, which are name and commission number of the notary public, expiry date of notary's commission, and notarial register entry. In deed of absolute sale, the consent is an essential element that may not always be labeled as a standalone section, but it is embedded throughout the document, especially in the introductory clauses and acknowledgement of the transaction. It shows that both parties voluntarily and knowingly agree to the sale, making the contract valid and binding. Consent is found in the deed, specifically in the opening paragraph, also in the transfer clause, acknowledgement before a notary, and consent includes the willingness to enter into the contract, the full understanding of the terms, and the agreement to the transfer of ownership. In deed of absolute sale, the object of the contract refers to what is being sold, usually a specific piece of real property like a land, a house and lot, or a condominium unit. The object can be found or the object is mainly described in the description of property section. It is also referenced in the transfer clause. It must be specific, lawful, existing, or determinable. The object includes the type of property, the technical description, the improvements, if any, and the ownership details. In deed of absolute sale, the cause is the reason or the consideration why the parties enter into the contract. In a sale, the cause for each party is, for the seller, the payment or promise of payment, usually a sum of money. This is the reason why the seller agrees to part with the property. On the part of the buyer, The transfer and delivery of ownership of the property is the reason the buyer agrees to pay the purchase price. You can see the costs in the deed of absolute sale in the consideration clause. This clause shows the cost for both parties. The buyer's cost is the transfer of the property, and the seller's cost is the receipt of the purchase price.
I will now explain the different kinds of obligation found in an absolute deed of sale. The first kind of obligation in an absolute deed of sale is a real obligation, which is also known as the obligation to give. This refers to the duty of the seller to deliver the property being sold to the buyer. It is a specific performance, meaning the seller must hand over not just any property but the exact property stated in the contract. For example, the deed of sale may state the seller hereby sells, transfers, and conveys unto the buyer a parcel of land described as follows. This confirms that the seller is obligated to transfer ownership and physical possession of the specific property. This kind of obligation is supported by Article 1458 of the Civil Code, which states that by the contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing. Next is the personal obligation, which means an obligation to do an act. In the absolute deed of sale, this usually includes acts like cooperating in the transfer of title, providing documents such as tax declaration, or signing additional paperwork when required. For example, the seller may be expected to assist in notarizing the document and executing an affidavit of non-tenancy. Meanwhile, the buyer often assumes the obligation to pay documentary stamp tax, transfer tax, and registration fees. This obligation is not about delivering a physical object but about performing duties. These are sometimes not explicitly stated in the deed but are still legally expected from both parties based on standard practice and jurisprudence. A determinate obligations refer to an obligation involving a specific and clearly identified subject. In a deed of sale, the object must be determinate, meaning the property being sold must be exactly and clearly described so there is no confusion. A line like, located at Lot 4, Block 3, Barangay Maligaya, covered by transfer certificate of title number 1234556, shows that the obligation pertains to only that specific lot, not just any land. This is important because in case of dispute, both parties can refer to this exact description, which limits the seller's obligation only to the stated property. An absolute deed of sale is a bilateral contract, meaning both parties have obligations. The seller's obligation is to deliver the property and transfer ownership. The buyer's obligation is to pay the full amount of the purchase price. This mutual responsibility makes the contracts fair and enforceable. The contract will not be considered fully executed until both sides fulfill their obligations. This is emphasized in Article 1169 of the Civil Code, which states that when the obligation does not fix a period, but from the nature and the circumstances it can be referred that a term was intended, the court may fix the duration. This shows that each party must act in good faith to fulfill what is agreed upon, even if the timing is not specified in detail. A commutative obligation means that each party gives and receives something of equivalent value. The seller gets the money and the buyer gets the property. This fair exchange is at the core of any sale of contract. It is often worded as, for and in consideration of the amount of 2 million pesos, the seller does hereby sell, transfer, and convey. The phrase "in consideration of" is legal language that shows this is not a donation or a gift. It's an exchange with real economic value. Both sides gain something and neither party gives more or less than what is agreed upon. Most absolute deeds of sale are considered to contain pure obligations, which means they are not subject to any condition or future event. They take effect immediately upon signing and notarization, especially if the payment is made in full at the same time. For example, the seller acknowledges full payment and hereby conveys ownership. This means that there are no suspensive or resolutory conditions. The parties are immediately bound and the sale is final. It becomes enforceable from that moment. All of the obligations discussed so far fall under contractual obligations. These are obligations that exist because the parties mutually agreed to them and signed the document freely. Under Article 1159 of the Civil Code, it is stated that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. This shows that once both parties have signed the deed of sale, everything written in it becomes legally binding, unless proven void or illegal. In this part of the presentation, we will discuss the legal implications and other important information related to the absolute deed of sale. We'll focus on the legal effects of executing the deed, the transfer of ownership, possible consequences for breach, and requirements under Philippine law. Obligation became enforceable by law. Once the absolute deed of sale is signed and notarized, the obligation of both the buyer and the seller become legally binding. According to Article 1156 of the Civil Code, an obligation is a juridical necessity to give, to do, or not to do. So, if either party fails to perform, for example, if the buyer fails to pay or the seller refuses to deliver the property, legal action may be taken and damages may be awarded. Transfer of ownership happens upon delivery. Under Articles 1477 and 1498 of the Civil Code, ownership of the property is transferred only upon the delivery. In the case of an absolute deed of sale, the notarized deed itself is considered a form of constructive delivery. However, for full legal ownership to take effect, the deed must be registered with the Registry of Deeds. Without registration, the title remains in the name of the original owner. Breach of obligation has legal consequences. If one party fails to fulfill their obligation, it can lead to legal consequences. Article 1170 of the Civil Code states that those who are guilty of fraud, negligence, or delay in fulfilling an obligation are liable for damages. For example, if the buyer fails to pay the full price as agreed, the seller may demand payment or even revoke the sale through court action. Notarization is required for legal effect. According to Section 11(2) of Presidential Decree No. 1529, also known as the Property Registration Decree, the absolute deed of sale must be notarized for it to become a public document. Once notarized, it can be presented for registration with a Registry of Deeds. A notarized deed is also admissible as evidence in court and is essential for the transfer of land title. In addition to legal obligation, there are other important details to consider. First, tax responsibilities. The seller is required to pay the capital gains tax, while the buyer must handle the documentary stamp tax, transfer tax, and registration fee. Second, due diligence is a must before signing the deed. The buyer should ensure that the title is clean, the property has no liens or encumbrances, and the seller has full legal authority to sell. Lastly, once the deed is notarized, the sale is considered final and irrevocable unless there is a clear evidence of fraud proven in the court.